case where the husband, this is the first case, right? The husband was charged with second-degree assault. This is a violent crime. And for the purpose of applying for citizenship, naturalization application form N400, the application was denied. Therefore, the wife green card application 2 was denied. We're going to talk about it. We're going to talk again about another case where the husband is an habitual drunkard. Now the wife is fearing for her life. In both situations, what are the best possible scenarios? What exactly can a person do? Those are two potential clients, right? My name is Bijoux Ngwanda. I'm an immigration lawyer, as you know it, based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. By the way, today I meet one of my viewer. I should have taken a picture of them in the store, right? The lady had her daughter. They finally recognized me from my YouTube videos. I forgot to take a picture so I can show you, but it was really nice to meet them. We exchange contact. Probably they're gonna reach out if they have questions. Let's start with scenario number 1. Well, this person calls me today because, first of all, she was denied a green card. The husband is a green card holder who applied for citizenship, and the citizenship was denied based on lacking good moral and character. The husband was previously charged with assault, second-degree assault, and assault involves crimes of violence. When it comes to violence, it just shows that the person lacks good moral and character. They have criminal record. They cannot get a citizenship within that 5 years statutory time. So they have to give it another 5 years unless that crime can be expunged, which is not as of this moment. So the person is going to have to wait for another 5 years, maybe in 2029 or 2027. I'm not sure exactly when that second 5 years is going to be set, right, for the application of naturalization for the second time. But in the meantime, based on green cards, the wife was denied green card, and the reason being, by the time of adjustment, as you know it, you must have maintained lawful status and be eligible to receive an immigrant visa. As we know it, for the purpose of the green card, if the person is not an immediate relative, because if the husband is a lawful permanent resident, for the purpose of the green card, that person is not an immediate relative, really. They're a relative, but not immediate, right? So visa has to be available, and you have to maintain lawful status, non-immigrant. The beneficiary has to maintain lawful status at the time of adjustment, or at the time the adjustment is taking place. So that's one of the reasons the green card was denied. So now the person asked me exactly, what can I do? Well, here's the thing, right? We always suggest that you just wait for the husband, for another chance for the husband to become a U.S. citizen. Once the husband becomes a U.S. citizen, and then the husband is going to be an immediate relative for the purpose of obtaining green card in the U.S., and that is going to waive unlawful presence for the beneficiary. So that's the best scenario, okay? Second scenario is you can ask for consular processing. However, the way it's gonna play out is this, right? You're gonna have to file the form I-824, first of all, to get the case transferred to a consulate abroad. And you can file as well a provisional waiver of unlawful presence, and once it is granted, then you can, once you visa becomes available, meaning the interview is ready, then you can go outside to get the visa. But that's risky. Not just risky, and because it's taking too long for the I-601A waiver to be approved, almost 3 years now, and not to mention the I-824. Let's say get approved within 3 years, and you have to wait on the line too for the consulate to have your interview ready, which is taking about 18 months for most. Once the NVC, like you are documentary qualified, it's taking at least 18 months for most consulates. So if you look at the totality of the years to be waiting, it's going to be almost 5 years. Pretty much the same time you have wait here safely to wait until your husband becomes a US citizen, provided that the husband in question does not get into another trouble, right? Because you cannot predict people's behavior, right? So if the husband does not get in another trouble, then the husband is going to become a US citizen, and they're gonna file for her, and less risk compared to the path of consular processing, okay? Because you always never know if you're gonna come back. Even if you get a waiver granted and stuff like that, things might go wrong at the interview and stuff like that. And then the person asked that, well, I've been here for 10 years. Can I qualify for another type of relief because I have sick children? The problem is her case was never referred to court, meaning that she's not qualified to apply for cancellation of removal. Can you apply for deferred medical action? Well, it's something you can do, but you know, it's just like it's a risk you take for deferred medical action, because you don't, first of all, know if it's going to be approved, and second of all, if it doesn't get approved, that might lead your case to be transferred to court. So those are the solutions, right? And cancellation of removal still is not guaranteed, right? You have to prove extreme and unusual hardship. So it's a long path. The best will be to just wait for the husband to become a US citizen, provided that the husband does not get into another trouble, okay? Second way scenario is just to go to consular processing, provided that you take all the precautions like waivers, transfer your case, and so forth. And third way will be to file for deferred medical action for the children, so you can get a work permit to work. If it doesn't get granted, that might lead you to the court, and in court you might be able to apply for cancellation of removal and hope it gets granted. But if you look at all that, it's just going to take some time. The waiting time for the citizenship is even better if we can get this husband to behave, right? That's the job of the wife. So let's talk about the second case scenario. The second case scenario is that this client of mine, potential client, I've had her consultation with her before, but this was just a follow-up question. She's asking about what exactly can she do, because the husband is habitual drunker, and it's getting worse and worse to live together. Right now she has this extension because she filed I-751 to remove conditions, and because, you know, those cases are taking too long, she's just right there and waiting for USCIS, because she got the extensions for 4 years, waiting for USCIS to adjudicate her petition. But in the meantime, it's getting really hard to live together. What can I possibly do? First thing to do is, if it's dangerous, you just have to move out, because we cannot stress enough about your own life, right? You have to protect your life. That's your own duty. In case of emergency, you call 911 and you just leave, right? Then you can file for a waiver of abuse if you feel like you have been abused in this marriage, or if you get a divorce, you can file a waiver of divorce. Those cases are really difficult. Strongly suggest that you have a lawyer to guide you through it, because it's about removing condition on your own. there's a lot to prove. The burden is very high and a lot is at stake. Okay, not to mention this person has children, almost to the point to come here because the green card was approved. Consular processing has already ready in terms of the interview has been done. They ask them to give their passport so they can put a visa on the passport. So I hope that they get their visa and they get here, and I hope that she eventually gonna find a solution in terms of either get a divorce or file for a waiver of abuse, because things are getting really risky. Anyway, the moral of the story is this: if you have a case that is really whether the case is easy or the case is difficult, you really have to consult. And guess why you need to consult? Because especially when the case is easy, when you really think that the case is easy, you have to consult. Because let me tell you about this one. I almost forgot about this case. I had a consultation last week. This person got into their first marriage. The person was young. They got into the marriage because they didn't have enough money. They filed their paperwork themselves. But what happened was they went to the interview as they were not prepared, separated into homes, inconsistencies in their responses. USCIS decided to deny the green card petition based on sham marriage. Now the person, the case was never referred to court. Now the person is in their second marriage. Unfortunately, his I-130 and green card was denied again based on previous marriage. So now they're fighting for their life, because now they have to show to the BIA, because now their lawyer filed an appeal to BIA, because they really have to fight, because it wasn't, according to them, it wasn't a sham marriage. Just like people were not prepared enough to face the interviewers because of lack of counsel. That's why I always tell people, going back to the moral of the story, is that if you have a case, regardless of the complexity of the case, whether the case is simple, whether the case is difficult, always consult with a qualifying lawyer in order to get better advice, especially a paid consultation, because now the lawyer is going to take the time to explain to you exactly what you can do. And sometimes get a second opinion. You talk to this person, you talk at least to 3 persons. That way you can really weight the answers and know exactly what you can do, so you can avoid those type of mistakes. Now this person is fighting for their life. 20 years in this country, a simple mistake of not having a lawyer resulted in USCIS denying his first marriage case. And now they're claiming sham marriage. Regardless, it wasn't sham marriage. Not to mention the former spouse has written an affidavit saying that it wasn't sham marriage. But unfortunately now the person had passed away. So the person is not available for questioning even if they go to court. Yeah. Consult. If you need a consultation with me, you can schedule it, my friend, by using the consultation link in the description box below. Until next time, bye-bye.